All right. All right. Welcome back. It's been a little while and sorry about that. Part of it has been I've been busy. Part has been um laziness. But the biggest part has been I've been trying to psych myself up for the Karen Reed trial, which is what we're here to introduce today. And I thought I'd be started with it a week and a half ago, but jury selection has taken forever and it's finally done. Opening arguments, well, opening statements, sorry, no arguments and openings tomorrow. So, for those of you who are new, because this is a new case, so hello, I'm Joe. I am an attorney. I am licensed to practice in the state of Utah, not Massachusetts, where this case is, but I've primarily practiced criminal defense. So, yeah, basically, we'll be live streaming this trial, and it's gonna be a shit show. It hopefully will be fun, but we'll we'll see. So, but that being said, let's give people a few minutes. This shouldn't be a super long live stream. Like I said, it's an introduction. But Robert Fortin, it's good to see you. Paul Berry, hello to you too. Uh Victor, yeah, what I know about it, this is going to be a shit show. It not so shit show. It's going to be nuts. Absolutely nuts. And like I'll explain my process for streaming a trial in a few minutes. So yeah, but Kevin Campbell, good to see you. I've missed streaming too. I just like I said, it's the combination of factors, and you're going to be getting me every weekday for 6 to 8 weeks. So, you know, by then you might reverse that and say, good riddance, Joe, we're sick of you. Um, and Paul Berry, that's exactly my standpoint, basically. It's so coming into trials that I'm live streaming, I I generally, well, I've only live streamed one entire trial, well, multi-week trial, and that was Daryl Brooks. And you know, I did have an opinion on that one, frankly. Although, really, I hadn't heard of that one really until he went sovereign citizen and fired his attorneys, and I was like, oh my god, I have to do this. Karen Reed. So even though I'm an attorney, when I live stream a trial, I come at it as if I'm a juror who knows the rules of evidence and rules of criminal procedure and that sort of stuff. So it's kind of I wouldn't get on the jury, but I pretend I'm a juror. So that's why this is the first year hearing me discuss the case is I've tried to avoid too much overexposure to it because I, I want to treat the trial as if I'm a juror. And so I haven't read all of the evidentiary motions and all that fun stuff. And yeah. But my initial thoughts, so let's set it up. Karen Reed is a finance professor, I believe, finance professional in the Boston suburbs. This is the trial is taking place in Dedham, Massachusetts, I believe. And she is accused of backing her SUV into her boyfriend, John O'Keefe, who he was a Boston police officer, by all accounts, great guy. He was raising his orphaned niece and nephew. And yeah, so she's accused of backing her SUV into him and killing him and basically leaving him to die in a blizzard. Karen Reed, on the other hand, accuses everyone else of doing it. His friends did it. His uh, friend's nephew did it. And anyone she can blame, she blames. And there's been an entire circus sideshow, to quote Tool, uh, 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 basically running parallel to this case. Um, and that all involves Turtleboy. Now, I think, that anyone is welcome to watch here. Anyone is welcome in the chat as long as no personal attacks, no racism, no isms, no personal attacks. Follow the terms of service and you'll be good. But I don't like Turtleboy. I think Turtleboy is a piece of shit. And I think he has done everything in his power to taint the jury pool, and he's probably been working with the defense. I don't know if he's been in contact with her attorneys or just with her. I believe he's been in contact with her, with Karen Reed. And he's facing his own charges for witness tampering, which I don't know, that there are some attorneys on YouTube who seem to be supporting him. I saw video, I was introduced to the case on Masshole. Kate, maybe a year ago, did her first video on it, and basically that was my introduction to the case. Like I said, I'm in Utah. It wasn't local news here. I don't watch the news anyway because it sucks. But when Kate first showed the video of Turtleboy at the lacrosse game harassing Jen McCabe, my reaction, and I think it's even in the chat on the Masshole video, was, how has he not been charged with witness tampering? And I was just getting ahead of myself because he has now been charged with witness tampering. And I bring this up because Turtleboy is going to be an issue during this case. So, and I'm sure we'll have some of his fans in here at some point, free Karen Reed and blah, blah, blah. And, another rule of the chat, no spam. If you want to say something, say it, but you don't have to repeat yourself. But yeah, so, and I should have said at the beginning, this live stream today, it's an introduction to the case, but it's not super formal. It shouldn't be super long. It's just the opening credits, if you will, sort of introducing you to the cast of characters who could play a role, what we expect, what could happen, hopefully. So, and Kevin Campbell asks a good question. Turtleboy is Aidan Kearney, however he pronounces his name. He is a dime store wannabe shock jock on YouTube. based in Massachusetts, and his channel name is Turtleboy Sports, I think. And he basically, he's a provocateur, glorified prank channel, if you will, and he's ridiculous. And Alpha Fox Adam, yeah, federal proffer, the whole federalism debacle in this case is nuts, because there was a parallel investigation by the U.S. Attorney's Office in Massachusetts that was most likely, it's all sealed. I don't know exactly what it contained, but it was most likely completely inappropriate. And but there's talk that some of the witnesses testified before a grand jury there. One of the witnesses gave a proffer of evidence, and so Turtle Boys fans are, he gave a proffer, that means he's guilty because he got immunity for giving a proffer, therefore Karen Read is innocent. And the thing is, a proffer is basically, it's an offer of evidence, where you're not being cross-examined. You're basically saying, hey, here's my evidence. It's essentially an oral affidavit, declaration. So the often what the feds will do is they will give someone immunity in order for them to give evidence, and that's called a proffer agreement, and or colloquially it's called the king for a day agreement. Basically, you tell us everything, and whatever you tell us during this we can't use against you, although if we find it on our own without your help, then we can. And so there you Turtle Boys fans are using this as, oh, hey, that means he's guilty. But the thing is, me as an attorney, let's say I try to introduce evidence in court and the prosecutor objects and the judge sustains it. Well, in order to preserve that for appeal, I have to put it on the record anyway. So we'll say, get the jury out of the room, and then I will stand up and, judge, for the record, I would like to proffer that this would have been the testimony I expected to receive from that witness had the objection not been sustained. And so I'm not facing any criminal liability, but I still gave a proffer. So that's a whole red herring. It's ridiculous, but it's fun. So, and Alpha Fox Adam, exactly. If he were given a immunity agreement, it would be for federal crimes. It would have absolutely nothing to do with Karen Read. It should have no impact on this trial. But, does it might mean he's a criminal in some other way. Who knows? Doesn't matter for our purposes. So, and basically, Ryan, this is my thought too. I believe she hit him. I do not know if it was intentional, but I also don't think it should matter, but that's more of a political issue than legal issue at this point. But that's more of, I'm of the opinion that there should be no crime called drunk driving manslaughter. Because to me personally, if you kill someone as a drunk driver, that should be second degree murder, because to me that's depraved heart. It's depraved indifference, and so that should be second degree murder. But that's irrelevant. And that's it, Ryan. I'm looking to see what is presented in court, and that's what I'll make up my mind with. I'm like I said, I think her car struck him. Now, it could have been driven by someone else. I don't know. It could have been an accident. I don't know. But I think she played a role. But that has to come out in court. And so I'm like I said, I'm trying to go in with an open mind. I'm pretending that I'm a jury. So it's yeah. But that being said, so I've pulled up a few news articles about the case, and basically it, basically what I want this article for is to sort of introduce our cast of characters. Like I said, it's this is the opening credits for a 6 to 8 week trial. So I think going in understanding who's who will help. So that's it. It's a primer. So this is Boston NBC affiliate, NBCBoston.com, and it's a timeline updated 3 hours ago by Mike Pescaro. Sounds kind of fishy to me, but who am I to judge? So January 28th, 2022, there's a group gathers in Canton, Massachusetts, and they went to CF McCarthy's bar in Canton, and then at 11 o'clock went across the street, Waterfall Bar and Grill, for about an hour. Then they went to the Alberts home, and at about midnight. So at 12:15 to 12:45, just reading straight from the article, and Kevin Campbell, thank you for joining as a member. I appreciate it. So multiple witnesses recall a dark SUV. Karen Reed drove a dark Lexus SUV. So multiple witnesses recall a dark SUV pulling up to the home at about 12:15. Jen McCabe, McCabe, I don't know if that's Jen or her husband. Should have read ahead. Says she, so Jen McCabe, sees a vehicle pull up around 12:30 a.m. and sit there for about 15 minutes, but no one comes inside and the vehicle leaves at about 12:45. According to the defense, she's been texting with O'Keefe, the victim, and the last 4 texts sent between 12:31 and 12:45 a.m. go unanswered. So, yeah. And Nima, hello. So 1:30, McCabe and the other witnesses all leave the Albert home, and the dark SUV isn't there. So 2:27 a.m., this is going to be a major point in the trial from what I understand. And so in court, in the rules of evidence, and basically there's a thing called the battle of the experts. And so Liz Lizard Breath, I appreciate you stopping by, and I will appreciate you being in the late night viewing crew as well. So in a battle of the experts, what happens is basically the prosecution will bring its expert who will say, yeah, we've run the analysis and this is our finding. And then the defense will bring their own expert and it'll say, yeah, we've run the analysis. The prosecution's expert is a moron whose degree should be revoked. And this is our result. And then the jury basically gets to decide what weight they give to each expert. And this expert with the 2:27 a.m. is going to be about internet searches. And so the defense alleges that records show that Jen McCabe's phone searched hosts, misspelling, how long to die in cold, uh, which would have been 3 hours before John O'Keefe was found in the snow. And prosecutors are saying, yeah, no, she actually made this search after he was found at the 5:30, 6 o'clock in the snow. And the prosecution is saying the reason 227 comes up is because that's when the window was opened on her phone, but that the actual search was made 3 hours later. Whereas the defense is saying, hey, she made the search. So she knew he was dead long before he was found. And therefore, Karen Reed didn't do it. Someone else did. And it's all an elaborate cover up. And I should have mentioned earlier, like I said, this is mostly unplanned, unscripted, I don't have an outline. So it's definitely not an opening statement, just opening credits. But most of these witnesses are fellow police officers. And so, yeah. And Christo, hello, good to see you. So basically 4:53 a.m., Karen Reed and John O'Keefe's 14-year-old niece. Remember, O'Keefe was raising his niece. So contact McCabe saying that O'Keefe didn't return home and they haven't been able to get a hold of him. So 5 a.m., Carrie Roberts picks McCabe and Reed up to go look for John O'Keefe. And at 6 a.m., they find him unresponsive in the snow outside of the Alberts house. So, and that's a good question, Kevin Campbell. The only one we know was driving drunk is Karen Reed. The others, I don't know if they drove, if they had designated drivers, if they had Ubers, whatever. Like I said, to me, drunk driving it's a big deal. I say as a defense attorney, my opinion is no drunk driving manslaughter. It should be second-degree murder or whatever the equivalent is, because not everywhere has first, second, third-degree murder, because 50 states, all of them a little bit different. But I'm also of the opinion police officers, judges, prosecutors, lawmakers should be held to the highest standard. And so, like, if they are out driving drunk, they should receive the highest penalty, because why should they be able to come after other people for drunk driving if they do it themselves? But I should, if I find time, do a video about that prosecutor in New York that didn't think she should be pulled over. But yeah, so Searching the scene, officers recover a broken drinking glass, consistent with the one that O'Keefe had been seen holding, drops of blood, and 6 p.m. they find 3 pieces of plastic consistent with Reed's taillight. The defense is trying to say the taillight was on top of the snow, it was planted, it was after. There's, I think it's a Ring camera video of Karen Reed's SUV from after 1:30 that shows the taillight intact. I don't think it does, but once again, that's for the jury to decide. And Christo, you must watch Artie's Corporate Fiction with Officer Murphy. That's an all-time classic. And Alpha Fox Adam, that's another issue that is going to come up. The Colin Albert, the teenage nephew of the Alberts, is another person that Karen Reed has tried to throw under the bus, suggest he's the murderer. He wasn't there, according to everyone else. So and then there's going to be discussion about the Alberts dog, who Karen Reed is going to claim Officer O'Keefe had bite marks consistent with a dog. The prosecution says it's not, and besides which, it's only on one side of his arm. I think the marks are on his arm. Like I said, I haven't followed too closely because I'm trying to go in without all the information. But either way, the dog wouldn't have been able to bite down. So, yeah. So, did they officially give up on the dog story? That's probably good because it seemed pretty ridiculous. So it took a while. They have charged her second-degree murder, motor vehicle manslaughter while driving under the influence, and that would be a lesser included charge. So the jury can find that the elements are all there for both of these, but if they do, she can only be punished for the second-degree murder, and then leaving the scene of a collision causing death is the third charge. So she was released on $100,000 bail, and yeah. So basically, that's, I think, what we're going to cover as far as the night in question. So, opening statements, Monday. Now, as most of you know who have watched me for a while, especially those of you who watched the Darrell Brooks trial with me, I'm not a morning person. I'm especially not an East Coast morning person because we're 2 hours behind the East Coast here in Utah. So while I will be live streaming the trial, I will not be doing it in real time. That's just too early for me. Plus, judging by the motions hearings that I have seen, it's probably going to be best to do it at 1 1/4 speed anyway. So I'm expecting to get started, at least for this coming week, at about noonish Mountain Standard Time. So that's noon my time, 2 o'clock Eastern Time. So Eastern time may be real time, but it's too early for me. So that's Paul, that's something I was going to bring up. I don't know how rich she is. I don't know how rich her family is. I don't know her attorney's hourly rate. But assuming they're $500 an hour, an 8-week trial, she has 3 attorneys. So assuming an average of $500 an hour, which isn't unrealistic for Boston rates. It wouldn't be unrealistic Salt Lake City rates. You know, especially real good experienced criminal defense attorneys, they might be $1,000 an hour. But this trial, just for her attorneys, for her 3 attorneys, it could be $1 million defense. And that's just for the trial. That's not including all the litigation that has led up to trial, which I'm sure has been several $100,000, if not $1 million already. So, and Brandon, I hope that your Sunday night face stuffing was delicious. Um, so yeah, basically, like I said, this trial could be $1 million. Now, why do I bring that up? Why do I bring that up? Well, number one, that's a lot of money. But number two, so the Turtleboy effect could make it even more expensive because, like I said, Turtleboy has gone out of his way to taint the jury pool. And frankly, they had a very difficult time seating a jury. That's a big part of why it took almost 2 weeks to seat a jury. That shouldn't happen. It shouldn't take 2 weeks to seat a jury. 2 or 3 days. I mean, here in Utah, we've got a case coming up that I haven't been covering it because, like I said, I don't cover local cases because I don't want to be conflicted out of potential jobs. But the Corey Richens case, the up in Park City, has frankly received more media coverage than Karen Reed, I believe. At least from the start, it has. It took a while to reach fever pitch with Karen Reed, at least nationally. And I don't think they're going to have a problem, even in Park City. Now, Summit County is a small county. But I think they'll be able to seat a jury pretty easily. It might take a couple days, but not 2 weeks. And Turtleboy is absolutely proud of it, Darcy. Absolutely proud of it. And I should say, based on your profile picture there, I'm a University of Utah fan, go Utes, but the Oregon Duckies are my number 2 team. I went to high school with Haloti Ngata, so followed the Ducks ever since he went up to play for them. But there are rumors, once again spread by Turtleboy, which, can you believe anything he says? But there are rumors that there might have been a Turtleboy follower, a turtle rider, as they're called, who slipped through the cracks and was put on the jury and said, "Oh yeah, I can be totally unbiased," and they're intending not to be. If that's the case, that could be $1 million mistake for Karen Reed teaming up with Turtleboy, because if there's one or two jurors on there that all the others follow the evidence and they say guilty, presumably, but one or two take their marching orders from Turtleboy and not guilty, that's a hung jury. And that just means they do it all over again. And that's another $1 million trial for Karen Reed to defend. And that's expensive. I don't care who you are. That's expensive. And frankly, if that happens, trial number two, there would be a very good chance that they say, you know what, Dedham has been tainted. We can't seat a jury here. And it moves to Boston. So if there's a retrial, I would expect it to be in Boston. And that, yeah, I don't, obviously don't know what the jury issue was, but I have a feeling it was discussing the statements that Turtleboy has made. So, oops. And well, wait, did your son, Darcy, did your son play for the Ducks or just at a student for there? But yeah, that Pac-12 championship, that was a fun one when Utah versus Oregon. Unfortunately, the Rose Bowl game that followed wasn't as fun. So Brandon, I can't give you the exact figures for it, the exact criteria for a change of venue, but it is very rare. And it's basically, you can't seat a fair jury. There's too much publicity, there too much notoriety, there too much community sort of intertwinement. So the um if the victim or the defendant has too many ties, so that uh, you play 6 degrees of separation from Kevin Bacon, and the if it seems everyone's 1 or 2 degrees separated, you can't seat them on a jury. So let it, you might not be able to seat the mayor of a small town, a jury against them. But in this case, with um with a clown going around harassing jurors, harassing witnesses, uh attempting to taint the jury, that might end up being grounds, especially if they fail to properly seat a jury in this, or find that they didn't properly seat a jury. And that's what it would be, Brandon. It would be a mistrial first, but then for the second trial, they would change the venue, I think. Now, and you're right, it is very rare, and it is brought up very often because you know um and so with my parents, I've actually discussed this, because the funny enough, Summit County, going back to Corey Richens, and Latah County, where Moscow, Idaho are very similar in size, in population, at least. Um, Summit County has 42,000 people. Latah County has 39,000 people. Now, Summit County seems considerably bigger, but it, it's the same reason why Las Vegas seems bigger than Salt Lake City. They're the same size metro, but Vegas has a lot more visitors. Well, Park City has a lot of visitors and a lot of vacation homes, so it seems bigger. But the that being said, I fully expect Corey Richens to be tried in Summit County because, well, number one, the murder took place in Camas, I believe, either Camas or Francis, right next door, and that's right next to, well, it's not right next to Park City, so that there's the entire rest of the county, whereas 4 students murdered at the University of Idaho, where the entire community is built around the university, that even though they're similar populations, the demographics are so different, the makeup of the communities are so different that 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 they just, to me, one, I think, can take place, the other has to move. And the problem is, Paul, with Koberger, frankly, I don't think it should even be a discussion. It has to be in Boise. It just has to be there. It's too notorious. It's too many ties. It's 4 victims, so that just, it quadruples the potential, contacts, the connections, and unfortunately, in order to get it moved, you have to prove you can't seat a fair jury, and in order to do that, Koberger basically has to do these surveys, and it so it's not that they're trying to taint the jury themselves, but that this is what has to be done. And like I said, I think it has to be Boise, Ada County. The other 2 counties they mentioned that they're doing surveys in are Bonneville County and, whoa, what is it? Either way, it's Pocatello and Idaho Falls are basically where it would be. And Boise, well, as I've said, I have a cousin in Boise, so, well, multiple cousins. So I could make a week of it and go to part of that trial. But Pocatello, I could leave 6 in the morning, and as long as there's no line, go to trial and then drive home at night. Pocatello's 2-hour drive. It's not bad. So, but yeah. So back to it though. So opening statements tomorrow, Monday, each side will have 45 minutes, and I don't know, some trials have had overall time limits. I don't know that this one will, but they're giving each side 45 minutes for their opening statements, and it says 10 a.m. Monday, which is 8 o'clock my time. So I'll be 4 hours behind, but like I said, we'll go 1 1/4 speed. And so we've discussed Turtleboy a lot, but well, one other thing that they're moving to a smaller courtroom for the trial. Uh, they've been in the big courtroom for everything pre-trial, but Karen Reed, that they've come in with this idea that the confrontation clause of the Constitution means you have the right to face, eye to eye confrontation, and everyone has to be able to see everyone in the eyes. And I don't know that that's necessarily the case. I don't actually think it is. I think the confrontation clause is you get to question the witnesses against you in court, confront them. But they've said we have to have eye to eye contact. The jury has to have eye to eye contact with the witnesses, and two of the jurors wouldn't be able to. Therefore, that's unconstitutional and blah, blah, blah. So I don't think it actually is unconstitutional, but the judge is going along with it. That's fine. Take away an appealable issue. So they're going into a smaller courtroom, which means there's really not going to be room for an audience. There's basically room for the victims' families, victims' families, Karen Reed's family as well, and the media section. There's no general admission, basically. So Turtleboy wouldn't be able to go if he wanted to. And that's it. I don't think it's the actual law. I don't think it's a bad policy. The witnesses should be viewable to the jury. I don't know that the witnesses need to be able to see the jury themselves. So, it could be put a monitor viewable by the jury that, put the witness on camera, put the monitor so that the jury can see it, and you're good. But yeah. But either way, one of the motions that I do know was brought was both sides brought motions to exclude mention of Turtleboy in the trial, which, well, frankly, fine. Turtleboy was not a witness. He was not at the McCabe home or the Albert home in January of 2022. He was not at the Waterfall Bar and Grill. He is not a witness. Now, that being said, he's not a direct witness. But assuming the prosecutors have analyzed his phone, which they should have, because he's a criminal defendant in his own right. And frankly, I'm surprised at this point. It may come out in the future, but I'm surprised there aren't conspiracy charges brought against both Turtleboy and Karen Reed for conspiracy to tamper with witnesses, to intimidate witnesses, because they've only charged Turtleboy. I really think there's probably a conspiracy there. It's a common effort, and maybe even Karen Reed's attorneys are involved too. And if that's the case, there wouldn't be attorney-client privilege protecting them. But that's aside from the point. But if there are admissions that she made in her communications with Turtleboy, Aiden could be called as a witness. The prosecution could call him as a witness and say, "So, is this your phone?" He'd have to say yes. Are these texts that you've made back and forth with Karen Reed? He'd have to say yes. And if, y- just hypothetically, there's a text that where she says, "Well, yeah, I did it. He was a cheating bastard. I had to kill him." Well, even though that might be argued as hearsay, it wouldn't be because it would be the admission of a party opponent. So the prosecution would be able to get it in via Turtleboy. Now, that's just saying, hypothetically, if there were texts between them. Now, I'm guessing since the prosecution probably does have his texts with her, maybe his voicemail, that there's nothing in there that they think they need. Otherwise, they wouldn't have brought a motion to keep him out. Now, the judge basically said, "Hey, he's not a witness, so why do we even need this?" But if he's brought up organically, that'll open the door, and the general rules are if the door's open, then you can go through that door. And so, let's say Jen McCabe is on the stand and she's like, "Yeah, that this midget wank goblin has been harassing me on behalf of Karen Reed." And the prosecutor, "So this wank goblin you mentioned, you know, that's how he could come in, but either way, um, yeah." So, and yeah, the shit very well may hit the fan. I mean, it the poop bucket's already up in the air, but it could hit the fan, and there could, like I said, there absolutely could be conspiracy charges coming. You know, you all have heard me say it's never RICO. It's RICO is the legal lupus. This actually might be RICO. Although I don't know that they'd have to charge it as RICO. They, you know, just charge it as a conspiracy because that's what conspiracy charges are for. You don't necessarily need RICO to prove it. But and like I said, I haven't followed it closely enough to know if they've perjured themselves. I believe they have said in the past that there was no contact, and it's been proven that there has been contact, but it's only perjury if it was done under oath. And so I don't know. I don't know that that's happened. So I have a feeling there have been lies. I don't know that it's been perjury. But so finally, pulling up the Massachusetts general laws. So just taking a peek at murder. So murder committed with deliberately premeditated malice aforethought, or with extreme atrocity or cruelty, or in the commission or attempted commission of a crime punishable by death or imprisonment for life, is murder in the first degree. Murder which does not appear to be in the first degree is murder in the second degree. So she's facing second degree murder. So they're not saying, the prosecution is not saying that it's with malice, premeditated. It's not extreme atrocity or cruelty. It's not in the attempted commission of a crime punishable by death or imprisonment for life, which would be treason, which, yeah. So that's the top bill. Like I said, I don't know if it's murder or manslaughter. I frankly think it's one or the other. And I don't like the way Massachusetts has this lined up. So yeah, I'm not gonna pull up the vehicle manslaughter because I think it's in the traffic code. I was having a hard time finding it, but either way. So yeah, I think that's everything I intended to cover in the opening credits, the preview, the appetizer. But do you guys have any questions? And anything you need to know going into the trial? I don't know what it is. It must be something in the water in Georgia that causes all the RICO. Funny enough, my dad's cousin, who lives in Georgia, actually does have lupus. So it must be the RICO lupus water virus or something in Georgia. I don't know. So perjury, let's see if we can find it in the Massachusetts laws. It's probably going to be a crime against public justice. And section 1, perjury. So just looking at section 1. So whoever being lawfully required to depose the truth in a judicial proceeding or in a proceeding in a course of justice willfully swears or affirms falsely in a matter material to the issue or point in question, or whoever being required by law to take an oath or affirmation willfully swears or affirms falsely in a matter relative to which such oath or affirmation is required shall be guilty of perjury. Whoever commits perjury on the trial of an indictment for yeah. So basically, if you've been charged, if you've been sworn in, so if you are sworn in and testifying in court, whether that's in a trial, before a grand jury, in a deposition, in a preliminary exam, if you have been sworn in to tell the truth and you lie and it's material, that's perjury. So, let's look back to the Delete Laws Vegas trial. So Delete Laws fans are trying to claim, oh, Officer Bork perjured himself over and over and over. And let's just say, so in his testimony, he said, yeah, I was wearing my uniform, which is what I'm wearing right now in court. But in the video, he actually had a jacket on over it. But it was part of his uniform jacket. Now, that wasn't an intentional lie. It wasn't the truth because he had the uniform jacket over his uniform. But it wasn't material because it was still the reason for the question was to ask if he was readily identifiable as a police officer. And whether it was the uniform jacket or the uniform shirt, either one shows him as the officer. So, number one, it wasn't material. It wasn't with the intent to deceive, but it wasn't a lie because it was a year ago. His memory was isn't perfect. So, um, and that Alpha Fox Adam brings up a good point. It's if you charge a witness for every little thing that they get wrong, no one's going to testify, at least not willingly, because you, things can be misinterpreted, they can be misremembered. It's really you're only going to charge perjury generally if it's something really material, a blatant lie, and it's just yeah. And so yeah, Paul, I the plan is not an evening recap. It's start the plan is to start the trial and go through the entire day of court, starting about noon my time at 1 1/4 speed. So yeah, it's I'm going to do the entire trial, just not concurrent with it happening live, if that makes sense. I so um and CJ5, if Karen Reed were not an attractive woman, I don't think Turtleboy would give two shits about this case. He I really think he's just trying to get in her pants. Whether that's ends up being a conjugal visit or not, I really think it's just, hey, she's a conventionally attractive woman, and I can hitch my wagon to her train and make a lot of fuss. So, um, and Paul, that's a big part of it. The during Daryl Brooks, well, number one, it was too early for me as well, but the all the breaks for sidebars and just being able to fast forward is a good thing, and being able to go at 1 1/4 speed is a good thing because the you know 8, let's say it goes 8 weeks, that's that's a brutal trial. And I realize it's even more brutal for the lawyers working the trial, but it's brutal live streaming an 8-week trial, trying to stay on top of chat and follow the evidence and giving commentary on it. It just it it's brutal. So doing it at 1 1/4 speed, I think, will definitely help. So, um, so I don't know potentially criminal. I know Emily Baker is live streaming it, which I was hoping this would be one of the criminal cases she skips, but yeah, I know she's doing it. I'm assuming Ricada will do it, but I don't know. I don't watch Ricada, and he might do it at night anyway. Um, I know uh lawyer will d I assume he'll be doing evening recaps because yeah, he's too busy to stream the entire trial, but, who else? There there's 1 or 2 others that like I said, it took a while for this one to reach fever pitch, but I think it's reached the point that most of LawTube is at least aware of it, and a lot will be covering it. I don't know how many will be live streaming it though, but the who else? I assume Runkle will be doing recaps. Um, yeah, I don't know. And Darcy, I think you're right. I think Turtleboy, like I said, he's a glorified prank channel. So, but that being said, it's going to be a long week. So, I think I'm going to leave you all there. Please do all the YouTubey things that I always forget to ask you to do at the beginning, like, share, subscribe. Um, and I realize it's a big commitment to watch the trial, but I hope you all come and watch it with me because it could be fun. And it could be some people have stayed away because of backlash, but y- y- Turtle Boy, he's a he doesn't have the power he thinks he has, and I like, yeah, he brings protection orders falsely and shit, but like, I'm not going to contact him, and if he emails me, I'll just block him. I don't think most of the lawyers are worried about that aspect for streaming it. And I don't know if DUI guy will be streaming it. I know he'll be covering it. I wouldn't be watching with him, but and that's it. With him, it's an echo chamber, and it's a loud echo chamber, but it's not actually big. And that echo chamber isn't here in Utah. And I assume Melanie Little, Darcy. I've seen a little bit about her. Yeah, I don't know who Coffin Daffer is though, but yeah. Either way, like I said, it's time for me to go make dinner. So do all the YouTubey things. I will see you for the trial, and yeah, thanks for joining me. Bye bye.